directly gone there, but because of this case, I have come. Madam.
You see,
Tomorrow
that
our day-
time and again.
Tomorrow, day after tomorrow, madam.
On the prayer of Mr. N.J. Das, learned amicus curiae. The matter being adjourned for the last time. So submit the matter day after tomorrow.
Tomorrow, day.
Day after tomorrow.
Mine. Highly
And
problem.
you be here. You will
Mine. Mine.
May I please the Lordship? Lordship, on Friday, I filed 2 writ petitions, Lordship. This is with regard to the e-auction by the bank. So there is some urgency in the matter. Can it be taken up today itself, Lordship? Because the e-auction has been issued by the bank.
No. It is only for list, mention for listing pertaining to.
Urgent matters are there, Lordship.
Oh,
That's why I'm
okay.
making a
So we
mention
are-
for this one. That was Friday, that was supposed to be listed on Monday. The mention was allowed, but it has not been listed yesterday, Lordship.
Let it come to, let it go.
Lordship, the
tomorrow.
e-auction is there, Lordship. That is the main difficulty,
So,
Lordship.
tomorrow.
Tomorrow.
Okay, because I think.
Today at 2, if it is possible, Lordship, because the date has been given and we have been directed to deposit a certain amount. We have deposited the amount. But with regard to certain amount, we are not in a position. That's why we are paying for this honorable court some equitable relief, giving some extension of time. We've approached the DRT, but DRT has
Let it
refused.
be tomorrow. Okay. When is the last date?
Last day 27 January was the direction given, 27 January. Then 2 weeks, yesterday was the 2 weeks.
No,
For
when is
deposit of the
when is
20%.
the last date for submission of your tender?
Not tender, Lordship. This is an e-auction by the bank,
Oh, e-auction.
by the bank.
So when
So
is-
20% direction was given by the DRT to deposit 50% of the total amount. So 50% out of that 30% we have deposited yesterday.
No, you see, I do not know whether these matters are going to be taken up tomorrow by us again also. So,
Lordship, since the urgency is there, Lordship, because this e-auction, they will proceed for the sale of my property, and this is my residential property, Lordship.
tomorrow. I don't think anything will happen tomorrow. Within one day, is there any chance of anything happening?
Tomorrow, Lordship.
Tomorrow.
Lordship.
My lord, may I be allowed to mention one matter, your lordship? Today, court number 2 is not sitting, and the items listed before court number 2, I am told that is to be mentioned before court number 5, my lord.
Not as per this notice.
Yes.
There is nothing with regard to that.
Already.
My lord.
Meet, please, Lordship. My lord, yesterday the honorable division bench one permitted for listing to do a writ-appeal today, my lord, but that bench is deferred. So I pray, my lord, matter may be taken up tomorrow, my lord. Writ-appeal, my lord. Connected matters, my lord.
Okay, wait. That first item, that first item, that is before division bench.
Yes, Lordship. This is
Okay.
Tomorrow, my lord.
It appeals.
Writ-appeals, my lord. Yesterday I was permitted to move today, my lord, but bench is deferred, my lord. So tomorrow there is some urgency, my lord.
Let it be Thursday. Let the new chief
My lord,
come.
here, my lord, hundreds of my lord, railway vending and catering, my lord, contact also removed by my.
When was the order passed by this land single judge?
24/1, my lord.
24/1.
1, my lord.
And today is what date?
Yes, I have filed, my lord, on my lord, last Monday I have filed, my lord. Last Monday I have filed, my lord. I was permitted to move today, my lord. Kindly tomorrow, my lord. Kindly, my lord. Otherwise, my lord,
Day after tomorrow.
tomorrow, my lord, kindly. Otherwise, my lord, all my lord units were closed, my lord, forcefully by the IPF, my lord.
This-
Tomorrow, my lord, kindly.
There are some personal problems because of this new
Yes,
chief
yes,
coming.
yes,
old
I
chief
understand, my
going.
lord.
So.
Let us take a
there's
chance,
something-
my lord, let us. Otherwise, I could have moved today, my lord. So,
And I've got the criminal matters also. We've got. Let it be day after. Day after. How does it matter? One day.
my lord.
Day after tomorrow.
Much of it.
May it please your lordship. Lordship, I beg to mention item number 4 of daily list. Lordship, the method can be taken up after 1 week.
Why?
Actually, lordship, we have received some documents which shows that in the during the time of the incident, the accused persons were juvenile. That's why we want to take the plea of juvenility and file an additional affidavit. So 1 week time may be given to file the additional affidavit. Lordship.
Okay, right. Miss
P. Borua,
Miss P. Barwa appearing on behalf of?
accused petitioner,
No, your name is not here in the cause list.
on behalf of D.K. Medhi.
on behalf of Mr. D.K. Medi, learned counsel for the appellant, submits that the appellant would like to file an application with respect to certain documents that has come into their possession, showing that the appellant, no, showing that the victim girl was a major. Correct?
Right.
Was a major at the time of the incident. He accordingly placed for 2 weeks time to file the application. On the prayer of the appellant's counsel, the matter is adjourned for 2 weeks.
Okay.
May I bid your lordship? Lordship, the item num 16, this matter list before the court num 2. This is very urgent matter, lordship. The matter may be list after 1 week.
This is, code number 2, there is no notice with regard to whether we can pass any order. No notice has been issued to the registry, by the registry to us. You approach the registry. If they say, if they can issue some notice, because out here as per the notice, mention can be made with respect to DB1 matters, not any other code. So if they said that this and let me sit singly also, right now I'm sitting in the DB. I'll be sitting singly later. So you can ask them that Justice Michael will be sitting single later. So if some notice can be issued to the effect that mention can be made before me, then I'll take it up. I'll see.
Always.
May I please, your lordship, I'd like to mention a matter for listing today, lordship. Today itself, lordship, the sale auction is there, lordship.
Huh?
Matter,
Which what matter?
so yesterday we had filed, actually, we didn't get the case number, we have a filing number on the lordship.
DB1,
Yes, lordship.
date appeal.
Sales, lordship.
What is the urgency?
So sale auction is on today, lordship.
Sale. At this stage, have you got the filing number?
Yes, I have filing number, but we didn't have the case number actually. Yesterday we had filed, lordship.
Whether it is under objection also, we don't know. Can it be listed tomorrow?
So lordship, today is on, sale auction is on today, lordship.
Sale of shares today. Okay.
May I please, your lordship, it is a listing of a mat application, your lord, matrimonial appeal, your lordship. Can it be listed on 20th of 20th of February, your lordship? Problem, your lordship.
Yes, madam.
Lordship.
Let us see the FIR.
Yes, lordship.
Page,
FIR page 5, lordship.
page 5.
FIR is by the father of the deceased.
Father of deceased.
Deceased woman, lordship.
Father of
This is woman, lordship.
deceased woman. Yes.
Yes, lordship. Humble submission is that about 5-6 years ago from today, the informant daughter Nibha Kolita Das socially got married with the below mentioned accused number 1 as per Hindu rites and ritual. After that marriage, informant's daughter went to the house of the accused along with accused number 1 and started their conjugal life. The informant's daughter gave birth to 2 girl children while living with accused number 1. From the very early stage of married life, accused number 1 physically and mentally tortured Nibha Kolita, daughter of the informant, at the instigation of accused number 2 and sometimes brutally assaulted her. Moreover, both the accused brutally assaulted the informant's daughter by demanding dowry of rupees 3 lakhs. Still, the informant's daughter endured all the atrocities to continue the married life. But around 10 a.m. today, that is 24/2011, again demanding rupees 3 lakhs as dowry from informant's daughter. The below mentioned accused person, with the intention to kill her, assaulted her brutally and poured kerosene on her person and set fire on her. As a result, the informant daughter sustained severe burn injury. Later on, hearing hue and cry, the neighbors went there and admitted the girl in half-drowned state at Gwalpara Civil Hospital. As the condition of the girl is critical, she has been referred to GMCH, but she passed away in Boko on the way to GMCH.
When did she pass away? Date?
On the same day,
On 24th.
24.
20th of April.
So, first she was admitted to Golpara Civil
Civil
Hospital.
hospital.
Then on the way to GMCH, she
Yes,
died.
Lordship.
Is there any eyewitness?
Eyewitness is not there, but the 4-5 years minor daughter, she was asked by the court and 164 statement was taken, Lordship.
Daughter is how old?
4-5 years, nursery student.
4-5 years. So 164 statement.
Yes, Lordship.
Which page?
Page 63.
Is there any dying declaration?
Yes, Lordship. Dying declaration, page 65.
Okay, 63.
One thing, Lordship, she is a minor 4-5 years old. Before asking her to obtain her evidence, Lordship, some question has to be put to see whether she is actually is capable. But in here, Lordship, I have not found those questions before.
Is there any citation in support of your submission?
Lordship, citation.
Then how, from where do you say that some questions
At
has to be
least to
put to
see
her?
whether that
From
is.
where do you get that? From where do you say? Is that the law made by Miss B. Sharma
No,
or made
Lordship.
by High Court or Supreme Court or by whom? From where do you say that some questions have to be put to her?
Lordship, because she is less than 7 years, so in that case,
If questions are not put to her, then what happens?
so to see whether actually she understood what she is.
Who,
Lordship,
who said that? It's
no, Lordship, evidence,
which
my child,
section?
how to treat a child witness.
So let us see
Lordship,
that.
Lordship,
Okay, you just tell me that.
Yes.
You see, you're going to teach me these aspects. Okay.
And that is only 164
yes.
trial length.
So it is there in 164 itself.
But she has not been examined by the trial court.
Okay, she's not been there. Oh, then there's no use.
No use.
But it is an exhibit, Lordship. It is treated
It
as
is an exhibit, but if she's not subjected to any cross examination,
Lordship.
then there's no, it cannot be admissible as evidence. So now let's go to the dying declaration.
Lordship. 65, Lordship. There is number 65. This dying declaration is recorded by PW7 and PW11 was present at the time of recording of this dying declaration.
Dr. S. Ali is PW7.
7.
He was the doctor in this
Yes, Gwalpara Civil Hospital.
Golpara Civil Hospital. So he's got no relationship with any
No,
party. He's got no.
relation.
So he's an independent witness. And then what is this? Ritu Mani
Yes,
Bairagi?
PW11, she is a nurse in the hospital. She was present at that time.
Nurse.
Yes,
So she's also independent witness.
independent witness.
Where is their evidence? Let us see. At page.
Page PW7 is page
30.
PW7 page 27. 26, starts from page 26.
Yes.
On 24/2011, I was posted as senior medical and health officer at Gwalpara Civil Hospital. On this date, as per police requisition in connection with so-and-so, I recorded dying declaration of Nibha Das, wife of Manish Das of Swaraj Road, Gwalpara. As per her version, on that date at about 10 a.m., her husband, under the influence of alcohol, started beating upon her and set fire after pouring kerosene oil on her body. And she was thereafter brought to Gwalpara Civil Hospital by an 108 ambulance. Exhibit 4 is the said dying declaration recorded by me, and Exhibit 4.1 is my signature. Nibha Das also put her thumb impression on her dying declaration in my presence. Cross. I did not mention in the Exhibit 4 as to the place of her preparation
No,
of dying
place of preparation.
dying declaration as well as time. In Exhibit 4, there are some overwriting done by me, but I did not put my initial on the overwriting. There is no endorsement as to who took the thumb impression of Nipha Das. It is not a fact that the thumb impression on Exhibit 4 is not the thumb impression of Nipha Das. I cannot say now the percentage of burn of the patient at the time of recording the dying declaration. Consciousness of the burn patient depends on the severity of burn, nature of burn, etc. It is not a fact that Nipha Das was unable to give dying declaration in the hospital. I did not mention the police reference case number in the dying declaration recorded by me.
So any lacuna, any infirmity in this evidence? Is there anything wrong with this evidence that has been recorded? No.
No, Lordship.
Okay.
This
no.
is
So
now I-
according to you, no infirmity with the evidence.
this then I want to read PW 11,
Yes, page
33, Lordship.
33. Yes.
On 24, 2011, I was posted at Gwalpara Civil Hospital as I was undergoing as
Male
male constable nurse at that time. On that date, one female burn patient was admitted at Gwalpara Civil Hospital. I provided her first aid and on duty Dr. Somser Ali attended the patient. At the time of treatment, Dr. Somser Ali recorded statement of the patient in my presence. The patient disclosed that her husband under the influence of alcohol causing marpit, poured kerosene oil and set fire on her. Thereafter, I put my signature in the dying declaration as witness. Exhibit 4 is the said dying declaration and 4.2 is my signature. Thereafter, I came back to attend other patient. Cross. Earlier, the patient was not known to me and I cannot recollect the name of the patient now. Police did not record my statement. I did not state before the police what I have deposed today in the court. While I was giving first aid, the body of the patient was covered by cloth and I did not see the injuries. As first aid, saline was given to the patient. It is not a fact that the patient was unable to speak. At that time, myself and the attending doctor present and no other person was there. It is not a fact that the patient did not give any statement.
Anything wrong with this? Nothing wrong. Okay, where is the post-mortem report or something like that? Or the evidence given by the doctor? Who is the doctor who gave the?
Yes,
who
Lordship.
gave the
PW 8,
Page
page 28.
28, PW 8. Doctor who made the post-mortem
Yes,
report.
Lordship.
Yes.
On 21/4/2011, while I was working as senior medical and health officer at Gwalpara Civil Hospital, I performed postmortem examination on the dead body of Nipha Kolita Das, female, aged around 26 years, Hindu by religion, wife and so and so. Brought and identified by so and so. External appearance: a healthy female dead body with rigor mortis present all over 4 limbs, about 80% superficial burn injury found over entire body except both lower limbs below knee. The blisters were already ruptured and there were a line of redness seen in some healthy and burn area. The base of the blisters were white in color. Thorax, walls, ribs and cartilages, chest wall burned anteriorly. Abdomen, superficial burn injury seen. Mouth, pharynx, asparagus, larynx is oedematous and contain blackish particle. Mouth and pharynx healthy. More detailed description of injury or disease. About 80% superficial burn injury found over entire body except both lower limb below knee joint. A zone of redness seen below knee joint of both limbs which separates the healthy and burned skin. Ruptured skin, vesicle seen over burnt area. The base of the ruptured vesicle contains clotted blood, looks reddish in color. Opinion: in my opinion, death was due to neurogenic and hypovolemic shock as a result of 80% superficial burn, which was anti-mortem in nature. Cross-examination: such type of patient having injury of such nature may talk for a certain period before death.
So this is a Golpara Civil Hospital.
Yes.
So the dead body was brought back. Time of death. Time on date
Time
of
of
death.
death is in the postmortem.
Because the first doctor's report is of 20.
Yes.
and 20 April, and this is 21st April.
21st April.
So when did he die or she die? I think it's that.
On the date of incident is, on that date itself, she was admitted. At 10, date of incident is about 10 a.m. So she was immediately admitted as per the evidence of the witnesses.
So anyway, those small things they have not.
Yes, Lord.
So what is their defense?
Of course, Lordship, there is dying declaration. Otherwise, Lordship, they had tried to project a case of 304B, but apart from the Azahar, there is nothing in the evidence to implicate the petitioner or his family members regarding 304B.
Implicate the appellant. you mean?
Yes, Lordship, appellant.
Is there any? What about the parents or the relatives
Lordship,
of the
although in
deceased?
the Azahar their name was there, but the appellant here is the only accused. They were this case was not against them, Lordship. This appeal is only by her.
No, I'm not on that. The deceased must be having mother, father.
Deceased.
Deceased.
Deceased, yes, Lordship. PW 1, 2, etc. All are
And what did they say? They also heard the dying declaration or what?
Oral
Huh?
dying declaration.
Huh?
by
they-
mother.
Mother.
Oral
Mother is-
dying declaration by mother,
Mother is PW number
PW 2,
2. And then
elder brother of the deceased,
PW number,
3,
3,
just a minute, elder brother of
and
deceased.
uncle,
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 and uncle, PW 10,
PW 10.
PW, elder brother of deceased is.
3W 3.
So they've all said that they heard.
Yes.
10
The
also,
dying
there is a oral dying declaration,
So 2, 3 and 10.
2, 3 and 10.
Anything
11
else, madam?
already
Madam,
11
Amicus
dying
here,
declaration.
Amicus.
Yes, yes.
He
Anything
was
else?
dead.
Lordship, not much.
So what was in 313? What did he?
3 only denial.
No
Only denied.
explanation, no
Only
explanation,
Silent or denied?
denied.
Denied.
Let us see 313.
Yes, Lordship.
Page.
30 starts from page 36.
36.
So only except
I have
in
nothing to say, no, nothing. So,
39
I have
on-
nothing. So basically, yes, so
Only-
silent plus denial.
yes, question number 13, his answer is that it is a false case and I am innocent. In reply to others, his answer is nothing.
So blank denial.
Yes, Lordship, denial.
So there was so the court can infer anything.
But one thing is that, Lordship, that he had tried to save her. It's not that he left or something, Lordship.
After burning her.
Yes, because she was in the prayer room, Lordship. She
Ah.
was lighting the lamp.
She's lighting the lamp.
Yes,
And so she burnt herself by mistake.
But he,
And her dying declaration is false.
no, I'm not saying it is false.
Then-
Because I'm saying, but it is also there that he tried to save her. It's not that he ran away or something like that. But it is definitely inside
Was
the,
there any burn injuries on him? No.
perhaps
He
these
was
things are not in the here.
Did
Lordship.
anybody, is there any evidence to the effect that he tried to save her?
Daughter's evidence is there. Minor daughter's evidence.
What does minor daughter say? So if you are going to accept the minor daughter's evidence to
No,
that effect,
I'm only mentioning that
page?
63.
63.
that portion is at page 64. And in the morning on last Wednesday,
You see, if you are going to say that her evidence has to be accepted, then we'll accept the entire evidence. You cannot say that we should accept only this part and the other part we should not accept.
Not.
So in the first part, she says, my father poured kerosene oil on my mother and set her ablaze.
Later, he took her outside the house by putting a nightie on her, dosed the fire by pouring water, and called an ambulance.
So what does it mean? That-
One thing that her evidence was taken on 24. The incident is of 20. and C is a minor.
So. Her evidence is corroborated, minor girl's evidence corroborated by dying declaration. And there's nothing to doubt her statement. This is a statement or no, this is a statement. This is a evidence. 164.
Yes.
Oh, 164 statement. No, 164 statement, the problem is that no, she was not examined.
Not examined.
Not examined. So then how can we accept her statement?
She was arraigned as a witness, but I've checked the orders. I mean, no reason shown why her presence was not sought for. I mean,
Ah.
now summons were issued. Perhaps she had grown by then and then she could not be.
Yes, maybe she might have changed her mind also.
Nothing in the order sheet also why.
Anyway,
her
that is a
presence-
different aspect. The dying
Yes.
declaration, there's nothing. Anything else, madam? Yes, the PP.
In fact, yes, dying declaration, Lordship will go to page number 63 once.
Yes,
The 64, no, 65. 65.
yes,
uh, It's a very short dying declaration.
correct.
I am Nibha Das. Little Lordship get 65.
Ah.
I am Nibha Das. Around 10 a.m. today, he returned home in an inebriated state, assaulted me, poured kerosene oil on me, and set me ablaze. After that, he brought me to the hospital.
So,
So very clear and all. And
yes.
police have also
And she's
recorded
got
her statement.
80% burns. You don't expect her to say a story, you know.
Hmm.
Once upon a time or something
Hmm.
like that. You don't have time for that.
Yes, 80% burn. And she was in a position to speak. Everyone has said.
Yes. So I mean,
Witnesses-
any citations or anything you all want to produce? No, nothing.
And there are so many but dying declarations.
Just give me one.
Uh,
Look, my brother knows the
Yes.
law. You all know the law. I'm the one who has to be taught.
No, Lordship knows everything.
No, nothing like that.
In fact, her statement, 161 statement is there of the, is it page 34, isn't it? Of the victim. No, her statement will be there
But
here.
then how does it matter? She's not been examined.
No, 164 of, 161 of the victim before she died.
Acha.
That can also be considered as a dying declaration.
Okay, where is that?
And no, police have stated about that. I'll find out the 161.
PW 12 is the IO.
PW 12. He said in the initial paragraph, I recorded the statement of victim woman Nibha Kolita Das,
Page?
page
34.
34. Victim women Nibha Kolita, it's there in the case record. Lordship will see the statement first. Fifth line from the top. There I interrogated and recorded the statement of the victim woman Nibha Kanta Kolita Das and also submitted prayer before the doctor to record a dying declaration. So her statement is in this case record because there was a judgment where it is said even 161 statement of the victim women before she died can be considered as a dying declaration.
Where is that?
That I had placed it once. And then, of course, here is a case, there is a case where only police have recorded. Here is a case where the doctor has also recorded.
But where is the statement under 161?
Why it is in the case record
It
that I
is
have
not in the
taken from
charge
here.
sheet.
Not exhibited, but
Not in the charge sheet also.
not in the charge sheet, but it is there
Then
in the
can we take
No,
cognizance
this
of
is
that?
161. only.
161 of the victim. So
Shouldn't
Lord-
it be a part of the charge sheet?
part of the
No.
charge sheet, but charge sheet, they make a consolidated report and give it.
But then all the documents that the prosecution are going to rely on,
Yes.
that should be in the charge sheet.
It is
Or
part
can you
of,
say it in the trial that, no, it's there in the in the police station or something.
no,
like
no,
that.
it
That
becomes
cannot be
part
done.
of, under 173, it becomes a
It's
part of the
charge sheet.
charge
So
sheet.
where is it? In this,
It is not
Not there.
annexed along with the paper book and not along with the charge sheet. Charge sheet, Lordship will find the, perhaps the mention will be here.
no, but if it is not here, how can we take cognizance of it?
Yes, but 161 of the victim, it is not simply 161 of the witnesses. It is victim.
But if
And
it is not brought to the notice of the court, can we consider it?
In that Supreme Court judgment, in fact, it was taken note of 161 of the victim women who died. And that was taken note of. Judgment I
Can you give me
had.
the judgment?
Judgment
give us the
today
judgment?
I don't have.
Anyway, leaving that aside,
Huh.
I think, but you please give that judgment to us.
Huh.
And another thing, I just want to clarify, I don't know, my brother might know, I'll ask him. The thing is that there is a statement made by the victim under 161.
Mm.
Now, if it is not brought to the notice of the court by way of a charge sheet,
Mm.
can we consider it? Or could the trial court consider such an issue if it is not brought to the notice of the trial court? That, that 161 statement.
Huh. It was brought to the notice of the trial court by way of police's statement that I have interrogated and I have recorded. But statement as such was not brought.
Then,
But she died, she could not have been again examined and all. So,
no, but the statement could have been brought.
statement could have
Could have
been brought and
to the
exhibited.
notice, yes, could have been
Had
brought.
it been exhibited, no issue. But here what the doctor has also recorded, so it takes a back seat rather. So perhaps it was not done.
That's all. Anything else?
And oral dying declarations, if your lordship wants me to
Yes.
see the 161 also, whether it was stated before the police in order to see the veracity.
Now, you see, if it's not part of the charge sheet, how can, why should we go into it?
And plus, the oral dying declarations were not it was not controverted by the defense.
Correct.
And in the cross examination also it stands. Nothing goes against.
And he has not given any explanation.
Yes, he has not given any explanation, and the police was also not confronted with those. There is no contradiction proved. No contradiction, in fact, brought on record, proving is
No
different.
defense witness, nothing.
No defense witness, he himself said. So the dying declaration coupled with the oral dying declarations, there are enough materials.
Okay, right. Right, Ms. V. Sharma, learned amicus curiae. For the learned amicus curiae, and Ms. S. Jahan. Oh, who is the parent?
I'm for the informant.
Oh,
That's number 2.
Ms. S. Jahan, additional PP, and Mr.
S. Doctor.
S. Doctor for the
That's number 2 informant.
for the response number 2 bracket informant. Anything to say?
You know, I'm assisting the public prosecutor.
Nothing to say. This appeal has been filed against the judgment and order dated 22/7/2019 passed by the learned session judge Golpara in sessions case number 289/2017, by which the appellant has been convicted under section 302 of the IPC and sentenced to suffer imprisonment for life and to pay a fine of rupees 10,000, in default to suffer simple imprisonment for 6 months. Actually, one thing, the conviction and sentence on the same day.
Let me see, I skipped that.
Was there any time period before the sentence was handed over? Was there any time period before the sentence hearing?
Lordship, I'll just see.
He sought for leniency. That page is here.
He was questioned under 257 now. But
7, 8, 13. Lordship, page 9. Oh, no. This is a leniency case to court.
So that
Not-
aspect,
No, Lordship, there is one page where he sought for leniency, Lordship.
no, leniency is a different thing. You see, usually some time is to be given prior to sentence hearing.
I'm just seeing the case record. Manish is absent with my judgment is. Now here on 22/7 judgment is pronounced.
Yes.
And then As per the judgment, the accused persons, namely so and so, is not found guilty. I heard PP. Recently, I heard PP, the accused had stated, and learned defense counsel on the point of sentence, the same day, 22/7. He heard the defense counsel on the point of sentence. The accused had stated he is innocent, he has retired from UCO and from his so and so. The statement of the accused in this context is recorded in a separate sheet.
So what have we said? Last. Okay. Now, what is the submission going to be? Madam Sharma? What? The learned amicus curiae, you just tell me, huh? The learned amicus curiae submits that
There's no ingredient of 304B.
that there is no ingredient of
304B, Lordship.
304B.
Except the,
Yeah, 4B, she's acquitted.
302.
4B, he's acquitted.
Ah,
Charges were under both.
Only 302.
302, Lordship.
Ah,
One aspect is that, Lordship, one of the witness told that there was some quarrel between them in the morning, Lordship. So whether it could be brought under 304.
Earlier also, there was a quarrel. She filed FIR. It was amicably settled. That part
okay,
is also
right.
there.
That's going to be your only submission.
That cannot be, because to bring it within 300 exceptions, she has to bring it within those 5
And
exceptions.
Lordship,
What am I
another
going to
thing is
record
that,
on your
Lordship, there
part?
is no eyewitness of the occurrence except the evidence of the
Okay,
minor daughter,
okay.
and which is also not a part, not.
Okay, right.
not
The learned amicus curiae submits that there was no eyewitness to the incident and that the statement record and then the recording of the statement of the daughter of the deceased under section 164 CRPC cannot be admissible as evidence
Lordship. And the one thing, Lordship,
as the respondent, as the daughter of the deceased was not examined
Lordship.
by the learned trial. Then what else? Full stop.
Another thing is that, Lordship, it's a residential area, Lordship, although neighbors are there, they were examined, but Lordship, they have also not actually knows how she was got fired, Lordship. If there is some incident took place and
That is covered by no eyewitness.
No, Lordship. And another thing is that, Lordship, the conduct of the accused, Lordship. Lordship, in the dying declaration also, she has stated that after that, he brought me to the hospital. So whether actually he has the intention, Lordship.
Okay. That's all.
Lordship.
The learned amicus curiae also submits that the neighbors of the appellant have also adduced evidence to the effect that they did not know as to how the deceased was burnt. Was
Yes,
burnt.
Lordship.
Was burnt.
Because they
Full
had
stop.
not.
Further, as the appellant's husband had taken as the deceased husband, bracket appellant, had taken the deceased to the hospital, comma, the same would imply that the appellant was in fact trying to save
Lordship,
the deceased
Lordship.
from the injuries sustained by her. That's all.
Lordship.
She accordingly feels that the impugned judgment and order should be set aside. Full stop. Miss S. Jahan, the learned additional PP, on the other hand, submits that she does not have any quarrel with the submission made by the learned amicus curiae that the statement given by the daughter of the deceased under section 164 CRPC cannot be admissible as evidence, in view of the fact that the daughter of the deceased was not examined by the learned trial court, and neither was a statement under section 164 CRPC exhibited in court.
It is exhibited.
It is exhibited.
Exhibit 3.
Exhibited by whom?
Exhibited by the police. No.
By the police, not by the
No, no,
magistrate.
no. Magistrate is not examined actually. This is,
Okay, cut that exhibit part. Just say no, not examined.
Hmm.
That's all. Exhibited by whom?
exhibit number kya hai beta? Ayu exhibit number 3. Number 3, I don't know. I don't say so, but exhibit 3 has not exhibited. I'm not getting it. Exhibit 3 was
Exhibit 3. Statement of
was
Prosecution
proved
exhibit.
by
If it was by the police, then how come? Was the police
exhibit
present?
no is the said statement. It was exhibited by the mother.
How? Mother was there?
PW2.
Okay.
I brought Isha to court.
Ah,
Her
okay, so-
statement was recorded.
Actually, it should have been done by the magistrate.
Exhibit 3 is the said statement.
Full stop. She also submits that the dying declaration of the deceased was recorded by the doctor on 24/2011. By the doctor, you put bracket PW-7, on 20/04/2011, and witnessed by the male nurse, bracket PW-11.
11.
Full stop. The learned additional AG also submits that the family of the deceased, that is PW number 7, PW number 11, and PW number 8, had stated that the deceased had told them that she had been burnt by the appellant.
PW 2, 3 and 10.
Oh,
Lordship
two, not,
has,
but PW 2, 3 and 10, sorry.
2, 3 and
2,
10.
3 and 10. 2, 3 and 10. Stated that she had been burned by the appellant, her husband, who had poured kerosene over her. She also submits that the evidence of the IO and the evidence of the doctors and the evidence of the doctor who conducted the post-mortem on the deceased clearly shows that the death of the disease was caused due to the burn injuries suffered by the deceased. As such, as the ingredients of 302 IPC were present, there was no infirmity. That there is no infirmity with the impugned judgment and order. accordingly, the appeal should be dismissed. Mr. N. Datta,
S.
S. Datta, learned counsel for the respondent number 2, echoes the same submission made by the learned additional people. First up, we have heard the learned counsel for the parties. It takes some time, so let's say judgment, hearing concluded, judgment reserved. Huh? Basically, you know what's going to come, but correction, this, that.
I'll bring those citations
Yes,
on the
bring the
next. step,
citations.
yes. Now, the dying declaration can be the sole basis of conviction, whatever judgments are there. I'll bring it.
And give me that 161.
161, yes, yes. I have placed it before Justice Suman Shyam. So it must be in somewhere. I'll bring it. 161 can be taken as a Supreme Court's judgment only. I'll give it to the court master in the middle.
We have got 3 and we've got 1 more. Oh, they were done. Yes.
No, please, Your Lordship. This is a criminal appeal jail, my lord. I am the amicus curiae here for the appellant, my lord. The
What is
challenge is
the,
to
what
the
is the section?
section 4 of the
Section 4,
POCSO
penetrative,
penetrative.
section 4. 10 years,
I have been convicted for 15 years.
15 years.
15 years, 1,000
Minimum
rupees
is
fine.
10, is it?
Minimum is 7 years.
7 years.
I'm sorry, just minimum is 7 years, my lord, which may extend to life. My lord, the offense took place in the mid-July 2018,
No, but 4:1
my lord.
says not less than 10 years.
My lord, that provision was changed in 2019. The offense took place July 2018. So it was the previous act, according to which whoever commits penetrative sexual assault shall be punished with imprisonment for
Okay.
either distinction for a period of 7 years,
Huh?
which may extend to life, 7 to life.
So it was prior to the
Prior
amendment.
to the amendment, and the amendment came into force with effect from 16th August 2019. I may please.
Give us-
Four, no?
The amendment is at section 3. In the Principal Act, section 4 shall be renumbered as section 4(1) and so and so. For the words 7 years, words 10 years shall be substituted. And it has come into force in the last page, Your Lordship.
It came into effect on August 6, 2019.
That was published. The
Public.
last page, my lord. The last page.
Notification.
The last page. It will come into force.
But minimum to put 10 years, will
16th August.
16th of August 2019.
in subsection one.
And the occurrence in this case occurred when?
Sometime in July 2018.
18, so it will be 7 years.
So are we in agreement on one point? First of all, before we proceed any further. If the offense was committed prior to the amendment, the sentence and has to be done in terms of the unamended section, is it?
Yes, yes. As far as,
So we
Punishment is
have
concerned.
got no
so
problem.
it
with
is
that.
anything 7 to life, so 15 years is given.
No, I just wanted to know
Minimum.
about
Yes,
the,
yes.
you see, the
As far
the
as
aspect of
proceed-
the minimum then the minimum sentence.
As far as procedural law is concerned, Lordship can take into account the amended, but as far as the charging sections, so it will be before the act, before the amendment.
Okay, then, yes.
13 years, not 13 years. 13 years.
My lord, I would like to place the FIR first.
Yes, yes.
It is at page 1, the
Yes.
format, and the FIR is at page 4, my lord.
Yes,
The FIR was lodged on 6th of August 2019, my lord,
2018.
2018, by the mother of the victim, Aimoni Sekia. She's
Yes.
PW3. She states, I have the honor to state that about 10 days ago, while I was away from home, my husband Sri Kanak Sekia committed rape on our daughter, Srimati So-and-so, aged 13 years and a student of class 6. When she told about it to my family members, he was questioned regarding that, whereupon he fled from the house. Yesterday, one of my family members caught him while he was hiding in the garden. And after that, we handed him over to the police. You are therefore prayed to take necessary steps and investigate the matter. So the FIR was registered under section 4 of POCSO and it was investigated.
76 also.
376 and FOXO.
Oh, yes. Charges were also.
376 IPC and POCSO.
Yes.
She was thereafter sent for medical examination, which is exhibit
Where is the?
exhibit 1 at page 46, my lord. Page 46.
Page 46.
46.
Page 46.
The FIR was lodged on 6th. Examination was done on 7th.
And what does it show?
I'll directly go to serial number 14, my lord, case history.
Serial number?
14,
Page?
page 48.
Yes.
Here the case history from the person, serial number 2, subclause 2, what the victims told the doctor. According to the alleged victim, in the mid of July 2018, during her summer vacation, while she was playing outside her house, her father, who was drunk, your lordship will mark that portion, he was drunk. While he was drunk, called her inside the house and started touching her breast and took off her panty and tried to insert. Your lordship will another mark, tried. It tried to insert so-and-so. She pushed him away and ran outside the house. After 2 days of the incident, she told her mother about it, and her mother told the village Gampura. They went to so-and-so police station. Complaint was lodged on 5th of August at 10:30 p.m. The police handed over the child so-and-so. So 2 points which I would like to highlight here is that the person, the accused, was drunk, and the victim and the appellant tried to insert. Tried.
No.
I'll place the implication later on, Madam. I'll place these facts first, because then it will not be a penetrative sexual assault. It will be simply a sexual assault.
Yes.
My
The
lord.
next point.
Next point is serial number 23 at page 51 of the same report.
Page?
51, serial number 23. The opinion of the medical officer.
Yes.
On the physical examination, on basis of the physical examination, laboratory investigation done on so-and-so, I am of the opinion that there was no evidence of recent sexual intercourse detected on her person.
No.
Secondly, there was also no evidence of injury detected on her person. And thirdly, that her age is in between 14 and 16. So there was no recent sexual intercourse detected on her body.
Anything else?
On the same day, thereafter, her statement was recorded under 164 minus on the same day. That
Whose
is exhibit-
statement?
The victim's statement.
Page?
Page 54, exhibit 2,
Statement of victim.
statement of the victim, madam.
164.
Yes.
She states that during summer vacation this year, I stayed with my father alone during the daytime. My mother works in the garden. That is why she was not at home. My father called me near him on 3 separate days. These are 3 different incidents, madam, on 3 different dates, and put his hand on my chest. He unbuttoned my dress and put his hand on my chest separately. And one day, laying me on bed, he inserted his genital inside my genital. He told me not to tell about it to anybody. As there was no one in the house, I didn't raise any alarm. Afterwards, I informed my mother about it. My mother informed the Gaobura. Later, police was informed.
This statement is
My-
made when?
On 7th, my lord. On the
7, 8.
7/8/2018.
Next day.
On the same day that her medical examination was done,
Okay.
on the same day.
So,
So, her statement before the medical officer that he tried to insert, and here she is saying that he inserted, are contradictory. Because before the medical officer might ask how much, in what way,
might not also ask.
might not also ask.
Tried,
But
tried,
before the-
supposing the male private part touches the female private parts.
Even that will-
Would it amount to insertion or would it amount to trying?
It comes within section 3.
Right.
Under section 3 it comes.
Hmm.
But in common parlance, as we understand it, what would you understand? You see, touching also comes under section 3.
It comes.
So with trying mean that supposing it touches.
After the words tried, she said, I ran away.
Huh?
She says, and he tried to insert so and so.
Huh.
She pushed him away and ran outside.
So can you,
See,
so
whether that-
when you try to do something,
But
say when you try to rape, what does it entail? It entails that both the private parts are visible and that he tries to do something. And in common parlance, what we understand is it has to be inserted a little bit at least. Okay, then what else?
now section 3 also say that the intention has to be there.
You are touching the breast of your child, you're doing this. So what more do
And
you
the
want?
moment, at the time he was drunk also.
So drunkenness is no excuse.
It's not an excuse, but
I think
he
with
didn't have
drunkenness,
that
there must be something.
intention. He cannot have the consciousness.
To prove কৰিব লাগিব section 30 proof to কৰা নাই proof কৰিব লাগিব যোগলে mental state নাই
No, correct. I leave around that point, my lord.
In
Section
cases
that-
where an act
that,
done is not an offense unless done with a particular knowledge or intent. A person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated. Unless the thing which intoxicated him was administered to him without his knowledge or against his
yes
will.
this is general exception
Yes. So
This exception,
under,
I
under
cannot
the
take. I cannot
IPC.
take this exception
Yeah.
because
So this 86.
I myself had taken
And
that.
section
Yes.
30 of the
Liquor.
POXO Act,
Ah.
there he has to prove that he did not have the mental state.
Ah.
Section 30 may be seen for the POXO Act. Because it requires a culpable mental state. If any prosecution for any offense under this act, which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, but it shall be the defense to
It
prove.
is similar to, I think, your 35 of the Indian PSI.
Oh, yes, kind of.
Similar to that. And
Very-
read with 86 of the IPC.
IPC.
He has to show that that
Ah.
liquor that he had drunk was forced upon him.
Yes, he had to rebut the presumption.
And it's not his case that, so that is gone.
Now the prosecution has stated the case as such that after the incident, after 2 or 3 days, the victim told her mother. The mother informed the other family members. They informed the villagers, the Gaambura. The police was called. When the family members got to know that such incident has taken place, I was confronted. And then I denied and ran away. I came back.
You ran away.
That is what the case has been projected by the prosecution.
Otherwise, do you have any other explanation for that?
I've just stated in my 313 statement.
Okay.
So for that, I'm saying.
Alibi Kusato. Alibi is there.
Alibi is there.
313.
So,
313 is
if I may
said
take
was not
to
there.
that point, my lord, at page 23, my lord, My-
Page 23 of the
of the
paper
paper
book.
paper. Yes. At 22, it starts my 313 statement.
This what I would say, I used to stay away from my house on earlier occasion. When I returned home.
Yes, 313 statement, what is this?
313 statement. my lord.
22 it starts.
22, it starts.
364 is the earlier section.
Okay.
At page 23, my answer to
So
the
they're
first
using
question,
an
my lord.
old form.
From below, it's around 5 lines.
Yes.
I used to stay away from my house on earlier occasion. When I returned home, the police caught me and brought me to the police station. I was surprised. I did not commit sexual assault on my daughter. So I used to be regularly away from the house. On the day I was arrested, I came to the house and I was surprisingly, I was caught. I had no clue. Now the evidence is, my lord. PW1 is the doctor. Similarly, whatever was recorded in her report, she has stated that. PW2 is the victim,
PW1 is the doctor.
is the doctor one,
Uh,
medical officer.
Just a minute. PW1 is the doctor.
Her evidence is at page 7.
Page 7.
Page 7.
Yes.
She is Srimati Sanjali Haflongba. She says on 7/8/2018, I was posted as demonstrator in the Department of Forensic Medicine, Assam Medical College Hospital. On that day, I examined Miss So-and-so, daughter of So-and-so, with reference to Tenganghat PS case number 57 of 2018, under section 376 and section 4 of POCSO Act. She was accompanied by Constable Mamuni Niyam and her mother. Regarding the case history, she says, according to the alleged victim, she has repeated whatever was recorded in the
So
medical report.
out here, it's again that.
It's the
okay,
same thing.
Same thing.
Same thing. Only in the cross that she was asked. On the next page, my lord, page 8, last 3 lines.
Yes. Yes, that.
The last 3 lines in her cross-examination at page 8, my lord. I have recorded the history of the case as I have heard from the victim. The victim was escorted by her mother and police personnel on the day of examination. I do not know if the victim was tutored. So in between, if she was tutored, she cannot say.
Yes.
PW2 is the victim, my lord, at page 9.
Yes. What does she say?
She says that the accused is my father. The incident occurred during summer months of the previous year, almost a year ago. I was alone at home. I was alone at home. At the same breath, she says, my grandfather was also present, but he is deaf and as well as blind. My father was also present at that time, and my mother went for work. My father called me inside and asked me to serve him food. I offered him rice to my father, but he did not have rice. He forcefully took me inside. He groped my breast and committed rape on me. When I protested, my father told me that he will assault me, and he forcefully committed rape on me. I experienced pain. My father threatened me not to inform my mother about the incident, lest he will assault me. I was reluctant to inform my mother. On the next day, when my mother was preparing to go for work, I dissuaded her from going to her workplace. When my mother asked me why, I narrated about the incident to sexual assault by my father. Here she says sexual assault.
You see, those
But it
are.
was-
Was the evidence taken in English or in
In English, my
vernacular?
lord.
It's in original.
It's the original. It's in English.
These are, you
Maybe
see, the
she have
interpretations.
interpreted it by
And
the
they
same
don't
judge.
expect them to be very well versed in English.
But in the same statement, in the same paragraph, above she says rape, and then next she says sexual assault.
I'm quite sure she doesn't know English also.
They are, these people are basically.
I know these have been
garden
translated
labour.
by the court because this child, I'm quite sure she doesn't know English like this.
She must have stated
It
in
says-
local language.
Yes.
They had recorded in English.
That is the
Hey.
thing. You see, actually, that is why the Supreme Court has said that as far as possible,
Hmm.
it should be recorded in the vernacular of that victim. So that there's no blemish here and there.
Hmm. It was recorded in English by the judge.
You see, even when evidence is recorded in vernacular and they are translated in the High Court, the meaning changes
Ah,
at times.
changes,
Meaning
changes.
Changes a lot.
Hmm.
So you can imagine in
Hmm.
the district court level, there's a chance that it will be changed even more. So I mean, few words here and there, minor inconsistencies, I think we can overlook.
Hmm.
Otherwise, nothing will really function.
Hmm.
Yes, then next.
My mother did not go for work and sat back at home. My father asked my mother why she did not go for work, and my mother lied that she was suffering from chest pain, and so she did not go for work. My mother was worried, and then she decided to inform my grandmother, that is my father's mother, about the incident, and then she informed her about the incident. My grandmother informed my aunt, that is Burma, about the incident. Everybody was worried at home, and then it was decided to hold a meeting. My father went away from the house, and he was not in the house for several days. One night he came and stealthily took away the voter ID card. The villagers were informed by my mother about the incident, and then they advised my mother to lodge this case. Thereafter, the police came and then called me to the police station, and then my statement was recorded. I was forwarded for medical examination and to the magistrate who recorded my statement. Exhibit 2, I've already placed my note at page 54. In cross, he says, there are about 2 or 3 houses near our house. I did not properly know the names of the residents of these 2 or 3 houses. My aunt house is about 3-4 houses away. The other houses are visible from our front courtyard and also from the backyard of our house. We are 3 siblings, elder brother, myself, and my younger brother. My brothers were at home at that point of time, and their statements have not been recorded. My elder brother is a student of class 8. My younger brother is a student of class 3. I was alone in the courtyard at that time. I did not hand over my garments, which were worn at the time of the alleged incident, to the doctor or to the police. It is not a fact that I falsely stated that my father committed penetrative sexual assault on me. It is not a fact that I was not assaulted. I did not sustain injury. It is not a fact that as I was not sexually assaulted by my father, so I did not inform about the incident on the same day. My father consumes alcohol, and so my mother dislikes him. I have come to the court today with my mother. My mother explained me about the case before coming to the court. We do not want to reside with our father even prior to the alleged incident. We do not want to reside with our father. There was discord between myself and my wife, and
About what?
because I used to consume liquor,
Besides that, no other discord.
no other discord. And this has been supported by others also, that there was a discord between the father and the mother, and they did not want to live with
Only over alcohol.
only over alcohol.
So there was no reason. Okay. That's all. Then, so, okay.
PW3 is the.
So there was nothing to divorce each other or separate each other.
No,
nothing.
nothing.
Tea garden
But
workers.
quarrels
habit
used
of
to take
drinking.
place.
Oh.
Quarrels used to take place between them.
Huh?
For the quarrels used to take place only because I used to drink. That's it.
That happens everywhere.
Tea garden, it is more.
Tea garden. It is.
Next.
PW3 is the informant, mother of the victim, my wife. I'm Moni Shekhar. So she
Okay,
says
so this is basically what has been stated
basically
to
the
her
same thing
by the mother. Correct.
as informed by the victim.
Anything else? Any other important evidence?
No, then PW4 is my mother, appellant's mother. She also
Okay,
says,
so now what is your case? What is the submission that you want to make?
my lord. In 164 statements, she said that there was nobody at home. But in her evidence, she says that her grandfather was there. And in the cross, she says her siblings were also there.
Evidence, grandfather.
Grandfather. And in cross-examination, she says her siblings were also in the house. She has also stated that she did not raise any hue and cry at the time the incident took
The
place.
PW number?
Says PW number 2.
So there are contradictions.
There is
Or what?
contradictions.
Huh? Contradictions.
And
And number
is-
2 is that tried to insert.
penetration, where actually
History.
whether it was proved.
In
Penetration.
164, it says tried to insert.
Tried to insert before the medical officer.
Before the
A
medical.
medical
officer.
officer. That is PW number
One.
1.
And in her statement, Exhibit 2, she has said that I have inserted my genital inside her genital.
In PW number 2
That is
statement.
Exhibit 2, my 164 statement. Victims 164 statement. Victims 164 statement
Victims 154 statement
says that he inserted his genital inside my genital.
inserted.
Insert.
And then in the evidence also.
In the evidence also. Somewhere she says rape, somewhere she says sexual assault. And there is no clarity as to when the incident took place, because it was mid of July. The incident was reported on 6th of August 2018, where in the FIR it says 10 days before. In her statement, it is around 4 or 5 days.
Anything else?
And if that penetration is not proved, then it will be an assault, sexual assault, and it will come under section 6, madam. Section 7, madam. Section 7, sexual assault, and punishment section 8, which would be 3 years to 5 years.
Anything else?
That's
That's all.
that's all.
No citation, nothing.
No, actually what happened
Because,
even
once
in
you
the
want to statement, you
earlier-
said it that I was not there.
in the
Again,
erstwhile bench, Justice Sumancham, and there we actually, he says, used to say that it is a fact. Every case depends on its own facts and circumstances. So in a way, unless it is it is required to a very great extent, we didn't do it. So this time we'll bringing all the citations. Like
You
in
have got to educate us. Yeah.
Lordship,
It's a two-way traffic.
yes, sir.
Once you give us, then we will try to give you also.
Lordship, yes. In fact, those basic decisions that in cases of this nature, the prosecutor's evidence both before the magistrate, before the police, as well as the trial court, if it tallies in the material particulars, then it will be a case of conviction.
Okay, then what is, now that's all.
313
is-
statement, madam.
Huh?
Alibi. 313 statement.
Okay, 313 years.
My alibi that I was not that at home at that
You were
point.
not at home.
He said that he was outside, he
Outside.
was not at home, but after he came back, the
He was
police arrested.
immediately arrested.
So it is not clear whether he was talking of before the incident or after the incident. He was not very clear on that.
Now the issue is, why should your daughter make a statement against you?
Her cross-examination, she didn't want to stay with me.
Huh?
She didn't want to stay with me.
She didn't want to stay with you. Did your wife want to leave you? Nothing.
She has
Now
stated-
she is staying in an orphanage. After the incident, she was kept in an orphanage and the villagers isolated them. Probably because of these kind of unnatural thing. Bizarre.
Your own daughter.
Hmm.
And anyway, the allegation, that is the allegation. Okay, yes, let us hear you.
Lordship, in fact, what he said, the contradictions.
Ah,
Here, the mother said that my sons were not at home. And in her cross-examination, she said, the daughters told her the brothers were not at home. Although she said the siblings were there, grandfather was deaf and blind. And whether the brothers were at all there at home, that is not undisputed. This is disputed. Because the mother said brothers were not there.
Because she was at work. She was
She
not
was
at
at work, but in her cross-examination also, the mother said, the daughter said the brothers were not at home. But my daughter told me that my sons were not at home at the time of incident.
anyway, so that is a discrepancy
In order to believe
or a
her
contradiction.
statement.
Contradiction. Huh?
Contradictions, because in order to believe her statement both before the trial and the magistrate,
Yes.
we have to see-
And what about his submission
sexual assault.
that with regard to the statement made by the prosecutors that tried to insert was there on the one hand, and on the other hand, he inserted his private part.
Tried is only in history of the, whatever she said before the doctor.
That has been exhibited.
That has been exhibited, but the law requires that her statement before the
Okay,
authorities.
now, if it has been, if he has inserted it,
Hmm,
please come to the post-mortem report,
hmm,
not post-mortem, sorry, medical report
hmm.
at page 50.
No, nothing.
Hymen is intact.
Hymen is intact. I've seen that. So it may not be that penetration, but even manipulation, when touching, those are
But
there.
then
in the-
he says
Hmm,
insertion was there.
hmm,
Insertion not of the finger.
hmm.
Now, does she, or how old was she?
13,
Huh?
13 years.
13. 13 is-
Of course, that contradiction, yes, it's there. But Lordship will go to section 3 again once. 3, it also includes not only the manipulation of the
You see,
parts,
if there
but.
is insertion,
Huh.
uh, saying tried to insert
Hmm.
and insertion are different
Hmm.
because he ran away or she ran away.
She
or
ran
something.
away, she ran away.
She ran away. Now,
She ran away,
So
yes.
he
she's-
tried to insert.
Huh.
It doesn't mean that the private parts touched each other.
Hmm.
But when you say that insert,
Hmm.
then it means that it touched.
Hmm.
Now
Yes.
there's a difference.
Hmm.
Now,
The Lordship will go to section 3 once again. Then the person is said to commit penetrative if he penetrates his so and so. If he
yes, yes.
inserts, then subsection C, clause C says
No, this
he
inserts,
manipulates.
inserts, even if it inserted 1 millimeter, it's insertion.
Mm,
No doubt
Mm.
about it. But does attempt or trying to insert
mm.
mean the same as insert? And why should we not believe what the prosecutrix told the doctor?
But the law requires that her statement
Her statement.
before the magistrate and the court should tally.
Where
Her
is that?
history, that I said, the basic judgments, I'll bring it. Because this is the requirement under POCSO.
If no, but then you see that is depends upon if the statement inspires the confidence of the court.
That is it.
You
Finds
see,
the
when-
confidence.
Yes.
Huh.
Now whether when she gives
Hmm.
two different
Version.
versions of the incident,
Hmm.
where she says attempt,
Hmm.
tried to,
Hmm.
and another is inserted.
Hmm.
Now it leaves a little bit of
creates
doubt,
doubt,
in the
yes.
in the mind as to whether what was she trying to actually say.
Hmm. And she was saying for many days he had been doing it. But in her statement again, she said, it seems it was only once.
And if
So
it has
some-
been if it has been done 3-4 times,
Hmm.
I'm quite sure the hymen would have been absent or torn or something like that.
Her statement before the trial court shows that it was only once. Mother said 3-4 days. But
Correct.
then her.
Now that is what. Now when you let us see the FIR again.
Huh.
FIR says
Has committed rape, simply.
my husband committed rape on
Hmm.
our daughter. Okay.
Yes.
Okay. Just yeah.
May I mention one matter, Your Lordship?
Yes,
My
we'll,
lord-
we'll be coming back in 1 minute.
Hmm. The section 7 learn is or no?
Section 7.
Sexual assault. Touches.
Assault or touch to the
Oh.
money law, the Chester had this. Assault.
Assault.
3 to 5 years.
Assaultable hobo. But section 3. মাকে তো সেটিং করে মাকে তো সেটিং সাইড
No, তাই নিজে কথাটা
আমার মধ্যে several times attempted আর 3-4 years আসলে বেসিক ডিসিশন তো সুমন চেমুটা নিয়া নাছিল তো জানি at the time of the interest he informed me. He also informed me
That
several
time,
times
160,
attempted.
160.
He took a mokoso,
164.
several times, sir.
Several times and
Three-
not just. That part only 1 day and 1 day laying on me.
পলাশ বাবুৰ ভয় যেন লাগিছে মোৰ এই My father called me near him on 3 separate days and put his hands. কোন কোন অপূৰ্ব শইকীয়া।
অপু শইকীয়া বুলি এটা আছে 7
অ' 6-2 অ' 6-2 টো অলপ বেছিয়ে কৈছে মানে মই যিয়েকৰ লগত যি মন যায় তাকে কৰো বাট দেন দ্যাট ইজ কন্ট্ৰাডিকশন হ'ল
কিন্তু পুলিচৰ কেতিয়া সেইকেইটা কথা
নাই হোৱা কন্ট্ৰাডিকশন আছে
সেইটো
মানে ই ধৰি পেলাই আনি পেলাই পুলিচৰ তাত চৰ মাৰিছে মানে
সোসাইটিটো একদম ভাল কৰি
কি যে কৈছে গিৰিকে ক'লে হি ৰিপ্লাইড হি ক্যান ডু হোৱাটএভাৰ হি প্লিজেছ উইথ হিজ ওন থটস সেইটো আৰ্গুমেন্ট কন্ট্ৰাডিক্টৰি
পুলিচে কৈছে আইও কৈছে কি মোৰ তাতেতো আহি কিনে কোৱা নাই
আপু শইকীয়া has not stated
সেইটো তাৰ প্ৰশ্নটো আছে তাৰ নিজৰ প্ৰশ্নটো আছে কি মই পুলিচক কোৱা
পুলিচক কোৱা নাই so contradiction is proved
তাৰ হেৰিটো এভিডেন্স চাই পেলাই লাগিছে অলপ something is
So anything else, madam?
Yes, yes. No, she was mentioning something.
You were mentioning, madam. Yeah.
Madam, the items before court of Honorable Acting Chief Justice, those items, my lord, can be mentioned before your lordships, my lord.
The
That is
DB1
the-
matters
My lord. This
at
item. was-
10:30.
My lord, I have tried to mention, my lord, but that is court number 2. I also mentioned, but somehow there was a confusion regarding the notice, your lordship. My lord, the item is listed as item number 2 in today's list, your lordship.
Item number 2.
My lord. Now, your lordship, there is a interim order in that matter, your lordship. The interim order is extended till 14/2. That is today's, because the matter was to be listed today, your lordship. Now, the matter is not listed before any court, my lord. Therefore, I pray before your lordship, my lord, this is a matter relating to the squashing of a notification of Mizoram, that's a Mizoram matter, your lordship, that the notification is way back in 1965. That notification, your lordship, makes the half a mile of both sides of the rivers, 14 rivers as forest, reserved forest. That was a notification. That notification was quashed by my lord, by the single judge, your lordship. So we have filed an appeal before your lordships, my lord, the appeal is admitted and also an interim order is given, your lordship, because if the stay interim order is further not extended, your lordship, deforestation
I
will
understand,
happen.
I understand your case.
My lord.
Madam, I think I was the counsel in one of the writ petitions
My lord,
in those batch of, prior to my elevation.
my lord.
I think if you look at the orders, in one of the, maybe 1 or 2 or 3 maybe also, I was the counsel.
1965 notification, your lordship, and the matter was.
I know, but then
It was quashed in January 20.
by Justice Ajit Thakur.
Just 1 second, 1 second. Yes, ma'am. Yes. Ma'am.
This matter pertains to, if I remember correctly, acquisition of land
My lord.
and non-payment of compensation in terms of the award.
Yes, but we are not on that.
You're
We are
not on that,
simply
you're not on
the-
that, you're not on that.
My lord.
But the learned single judge has quashed that notification of 1965.
Yes.
while considering this issue.
Yes.
Now, I was one of the counsels in one of the writ petitions with regard to the compensation.
My lord.
So as it is, I don't think I can take up this matter.
My lord, basically, my stay order basically goes today because it's not listed before any.
Take an extension and then list
How
it
can
for
I
other
extend
bench.
it?
I think I was one of the counsels. You just check one of the orders, you just see the file. I don't think it is proper for me to, I understand your problem, but that is my problem also.
There is another division bench as well. There is
Where?
another division bench of
The
Justice.
Notice says that it can be mentioned before.
You
since
see,
it-
what we can do is, madam, we can. But then you see, what is the notification was issued by? By order of both.
Notification says any listing. So go and list before them today only.
No, here, before my lord's.
Yeah,
Before the
later
all
order
DB
here.
one matters have to be mentioned here.
Mentioned here. So listing, perhaps Lordship can again direct listing of the matter today there in the other division bench.
But I do not see my lord's name here, my lord's. in the
No,
order.
because you see, much prior to the order of the single judge, I have been elevated.
I understand,
So
but I'm not
that's it.
understanding my
But
predicament.
I understand the problem.
I'm
And
limitless.
believe me, it's no difficulty. I don't have any qualms about, extending the stay order due to the problem. Unfortunately, I was a counsel now, it would not look proper for me to do it.
My lord can fix the matter in March anywhere before any.
And say what?
Interim?
What about the interim? You see, this is only for mention. Okay, we'll discuss before. Just check. No, don't write anything. List the matter at 2 o'clock. At 2. Have you given mention memo?
My lord,
Have you given a mention memo?
my lord, we have, we have WhatsApp and the learned AG was also present at 10:30. He was there.
No, you give a mention memo, let it be listed before us. This matter is not listed.
Yes,
Listed before us, then we'll see.
my lord. 2 PM. my lord.
You give a mention memo.
My lord, I'll give it right now.
No, apart from, it's not sure. No, I'm talking about this matter.
Yes.
Apart from the statement of this mother, father, there is a statement of another witness, PW number 6. He is somewhat a distant uncle. He in fact caught the accused and handed over to the police. And while stating various statements, he said that when he caught the accused told him, I can do anything with my own daughter. That, of course, there are so many contradictions. That has been proved. He said he did not speak it told to the police. Police also said he had not stated. So contradiction as such is proved with regard to other statement. But as far as this statement, there is no contradiction. I can do anything with my daughter. That part Lordship can see, PW number 6. Page
17.
17, yes, 17.
Yes.
Lordship will see, after skipping 10 lines from the top,
Yeah.
I brought the accused to his house, called the villagers. The accused tried to escape, but he could not escape from me. The villagers were present, and when we confronted him, the accused initially denied. But he replied that he can do anything, whatever he pleases with his own daughter. Then the police was informed by the Gambura, the police came and apprehended. And thereafter, Lordship will go to his contradiction part. It is not a fact, Lordship will, I heard from this incident. It is not a fact that in the beginning of the cross-examination, it is not a fact I have not.
Where are you reading?
Page number 18.
18, yes.
After finishing his examination in chief. It is not a fact that I have not stated before the police that I asked the victim, I asked the victim, she stated that the accused committed so and so. It is not a fact. I have not stated to the police that the accused was hiding and he used to visit his mother. And then I was searching for the accused and I met him in night and I caught him and asked him. He replied that he was returning from Duliajan. Then I brought the accused to his mother's house and called the villagers. Then I confronted him. In presence of the villagers, the accused initially denied, but he admitted that he could do whatever he pleases. Here he says, and then the Gaon Bura informed the police and the police arrived and the police apprehended the accused and the accused threatened me that as soon as he will be released, he would kill me. Around 50 people were present. I heard the incident a week before the so-and-so are there. In the police's statement, Lordship will go to PW number 8. PW 8, it is at page 20. The relevant part is at page 21. Oh, you can underline also. Lordship, it is at page 21. Cross-examination part, Lordship will go to the middle part of it. Oppu Saikya.
Who is he?
He is PW6.
The Ayub.
But Oppu Saikya is PW6. Did your Lordship get Oppu Saikya?
Yes, yes.
Oppu Saikya has not stated under section 161 that when he asked the victim, she told him that her father committed sexual assault. She has also not stated that accused was hiding and the accused is to visit the house at night. He has also not stated under 161 that the accused confessed that he sexually assaulted his daughter. He has also not stated that the accused threatened him that after getting out from the jail, the accused would kill him. The accused was assaulted by the villagers. It is not a fact that I have perfunctorily investigated the case. So as far as few parts, the contradiction is not proved. So this is only a statement which will again corroborate, nothing to do much. But then when he caught him, he said this before all the villagers.
Anything else?
Nobody else has corroborated that I stated
That the statement has not been
that I can
stated
do
by
anything
anyone.
with my daughter.
So that part is there.
His 161 statement is there, that can be seen.
161 Lordship, if your Lordship wants me to read out that. Not otherwise not required, but. So as far as the contradiction of inserting and trying is concerned, that is there. And a Lordship has to believe it.
Why?
No, Lordship has to believe the entire story on the basis of the evidence. So if only the statement before the magistrate and the trial court will not do unless Lordship believes the story. Here, of course, the contradiction comes regarding trying and the.
That is the thing.
that
aspect. You see, with the other aspect of touching the breast and all that is there.
That is there.
But however, with regard to penetrative sexual assault, there is a contradiction. Very
No,
much.
insertion is not only, insertion is not the only thing is in
Correct,
section
correct.
3.
Correct.
So section 3, there are other things, clause C, if he manipulates any part of the body of the child.
Okay.
So as to cause penetration into the vagina, uterus, all those. And
So
make,
as to cause penetration. You see,
so as to
at the end of the
cause.
day, there has to be an insertion.
No, so as to cause, but
So as to
if he
cause.
manipulates.
No. He manipulates so as to cause, but if he doesn't cause penetration, then will section 3 be applicable?
Lordship, in my humble submission, here penetration is not required under
Where-
clause
where-
C.
where?
Clause C. If he manipulates,
Yes.
manipulating is enough. So as to cause,
No.
cause may not be there.
No. So as to cause, it's a joint thing. It cannot be separate.
It's
Then
not and caused.
then why should they say so as to cause? It's not required. They could have stopped the legislature, could have stopped the thing there. He manipulates any part of the body of the child. If that is enough, then why did they add the other portions of this provision? If it's not required.
No, Lordship, in fact, I have filed one appeal and while going through the appeal, I have researched the work and I got one decision on this.
You have
because-
got, but you have not bringing
Yes.
it to our notice. You have
No,
got everything
here-
in your
Yes,
in
sir,
your
of
library.
course.
Then
that the interpretation, Lordship will again read it. If he manipulates any part of the body of the child, it is not and caused
No,
penetration.
no.
So as to.
So as to cause.
Huh.
So at the end of the day,
Hmm.
it does not say so as to attempt penetration. Or so as to penetrate. It says so as to cause penetration. It means to penetrate. It doesn't say so as to attempt penetration. It says so as to cause penetration.
Can be an interpretation, but then so as to cause,
First of all,
that causing will not be there. That manipulation.
when you say
Mm.
penetrative sexual assault
Mm.
in the first instance,
Yeah.
the word penetration connotes that
Mm.
there has to be some kind of penetration.
Yes, the head of the section provides
Ah.
penetrative sexual assault.
If there,
But
except for D.
Mm.
D
but D
says-
also says he
D-
applies his mouth.
Yes, he applies his mouth to the penis, vagina,
Mm.
anus, urethra. Now, where is that?
No
After
allegation.
application of mouth.
No,
So
that is
D,
not there.
D is slightly different according to prima facie, according to
Mm.
what is written
Mm.
in the section 3. 3 ABC
Mm.
requires penetration.
Mm.
For D does not require penetration.
Mm.
It just requires the mouth to be there in those parts
Mm.
of the body.
Yes. Mouth, of course, is not the case here.
There is also
Only-
no allegation of any manipulation.
Huh?
There is also no allegation of any manipulation. If touching is manipulation, then it would come under section 7 matter. It's separate. Touching is separate.
No, manipulate when you touch, it means manipulate. You're not supposed to touch a
But
girl's
it's-
breast.
But it's separate.
And
In
a
section
touch-
7.
Huh?
In section 7.
Ah,
It's separately provided.
correct. No,
Touches.
manipulation for the purpose
For
of
the purpose of
penetration.
penetration.
For the purpose
For
of
the pur-
penetration,
for-
yes.
No, but for the purpose of penetration and for cause of penetration is different.
Mm, mm,
You see, out here to cause penetration. it
mm,
says.
mm,
So when you say to cause something to be done, it has to be done.
mm,
Purpose might be different
mm.
because you might not have the end result. But when you say cause penetration, prima facie, it appears that penetration has to be done. Whether it is 1 millimeter or 2 centimeters. Anyway, that is the, now the issue is when the victim girl has stated to the doctor,
There
why
lies
should we
the,
disbelieve what the doctor says?
she went with her mother and she said yes.
She went with the police also.
Constable was also.
Now, why should we disbelieve the doctor? Why
There's
should we
nothing to
believe
disbelieve.
only a part of the doctor's evidence and
Mm.
not the whole evidence?
Yes, Lordship has to
And-
see the whole
yes,
evidence.
And if there are two views that you can get out from an evidence that has been adduced, the one view that supports the case of the accused maybe we have to lean more into it.
Mm. Yes.
Yes. That's
My
all.
lord, I am the amicus on behalf of the victim.
Yes.
My lord, my only submission is that in view of the provisions of section 29 and 30, the burden of lies upon the accused person to prove his innocence. If your lordship kindly see section.
That will come
29.
when the foundation has been.
Yes, and he has not given any evidence or nothing.
But then the prosecutor's evidence in itself is in contradiction, appears to be in contradiction.
But section
When she
29,
says,
unlike other cases under CRPC, the Special Act specifically states under section 29 the presumption to be taken. Kindly take up, let us read section 29 of the Act. Where a person is prosecuted for committing or abating or attempting to commit any offense under section 3, 5, 7 and section 9 of this Act, the special court shall presume that that person has committed or abated or attempted to commit the offense, as the case may be, unless the contrary is proved.
Agreed. But when the evidence itself given by the main prosecutrix is not in sync with one another, then how do we say that the foundational facts have prima facie been proved?
But evidence of the victim is very clear, Madam. Chair.
And the doctor's evidence, who is an independent witness, he says that he heard the victim say this. Can we say that the doctor's evidence is wrong? He heard wrong.
Otherwise, it's an opinion of the doctor,
Okay.
but
It's narrative of the victim.
Brief
history.
History, it's a case.
Brief history is a history.
As
And
narrated by the
history,
victim.
the history of the case has not been made up by him. He did not dream about it. He heard about it.
Hmm.
And I think it was stated to him by the
Victim,
prosecutor,
narrated by the victim.
narrated by the victim.
According to the alleged victim
Correct.
in the May.
So that, I leave your on your logics, but the burden of proof, which is on the accused, that has not been.
No. You see, it's the same as section 35 of the Indian PS Act.
Madam.
It does not absolve the prosecution from proving the case beyond all reasonable doubt.
In fact, Madam, division bench of this honorable court, I could not find that whether it is quoted in criminal appeal jail appeal 15 of 2019, which has been decided on 16/12/2022. In paragraph 86 and 89, the scope of section 29 of POCSO Act has been elaborated. It's
Sure.
it's not reported.
The problem is that you all tell us
Yes.
all this as if we are an encyclopedia, we know everything.
This will not happen from tomorrow, and I'll bring those judgments.
When you rely upon something,
I've given the.
You've given this.
Yes, but this has not been reported in any journal.
What have you given?
The case number, criminal appeal, jail appeal 15 of 2019 by this honorable court, Justice Minor Justice N. Kodisar Singh and Minor Justice Edi Chaudhary. It was decided on 16/12/2022. May I just read two paragraphs from that judgment.
Yes,
Paragraph 86. If we keep in mind the provisions of POCSO Act, what we find is that unlike the case of conviction under the Indian Penal Code, in which the burden of proof is squarely on the prosecution to prove the charges beyond reasonable doubt, in cases involving the offences under the POCSO Act, in view of the provisions under section 29 and 30 of the POCSO Act, such a burden which is solely cast on the prosecution gets shifted to the accused where a person is prosecuted for committing certain offences under the POCSO Act. Under section 29 of the POCSO Act provides that where a person is prosecuted for committing or abetting or attempting or to commit any offence under section 3, 5, 7 or 9 of the Act, the special court shall presume that such person has committed, abated or attempted to commit the offence as the case may be unless the contrary is proved. Now, my lord, here, another case has been referred in paragraph 89. As far as the scope of section 29 of the POCSO Act is concerned, it has been elaborately discussed in another judgment by a single judge of this court in Bhupen Kalita versus State of Assam 2020 SCC Online 2020-30. But that judgment also relied upon by this division bench.
next time you send us your judgments by WhatsApp also. So that we'll all take out our phones.
I have given, but they say it's a voluminous judgment. It's a page 66 page judgment, and this has not been reported anywhere. I could not find it. Otherwise, I could have.
What is the citation?
Yes, there is no citation.
I mean, what is the
criminal jail appeal, criminal appeal jail,
criminal appeal jail?
15 of 2019.
15 of 2019.
And it was decided on 16/12/2022.
16/12/22. Para?
There are 86, 89.
86, 89.
This is, paragraphs. This is regarding the, say, 29 and 30 of.
You see, during trial, no doubt, the onus of proving that that he's innocent shifts to the thing. But that does not absolve the prosecution from also playing their role. It's not a one-sided affair.
There are some contradictory, I could also find.
There are Supreme Court judgments also. If you look at section 35 NDNPS Act, POCSO, I'm not very familiar. There are some, and those, the ratio decided in those cases can easily be brought to their own.
Well,
Because it's the same words.
My humble submission would be this doctor's opinion or the history, it is at best can be said as a hearsay evidence. She heard from the prosecutors and she said, here,
Okay, hearsay.
that can be a hearsay. But in such cases, of course, not backed by the judgment. Here, if we see her 164 and her statement before trial court, that tallies.
Okay, right. Right, Mr.
D. Prasad.
D. Prasad, learned amicus curiae. Also had Ms. S. Jahan, additional PP, and Ms. Mr.
amicus for the, A.
A. Dhar. Learned amicus curiae for the respondent number 2. Hearing concluded, judgment reserved.
I'll give the judgment on that. The requirement in POCSO case, only her statement. That
No,
I-
that is already there.
That is a
But
settled-
what about, what about the
Mm.
narrative made by the
Hmm.
doctor?
Because again,
What is the value of those?
she heard, it's a hearsay rather. I'll try to get a judgment on that.
Yes, that will be very relevant.
Because that will create doubt. That was what, yes.
She has, on the basis of the narration, she has examined the victim.
No, so you can, if you can give the judgments on that aspect, by when can you give those judgments?
This, yes, narrative,
Tomorrow,
as far as, yes, tomorrow, yes.
by tomorrow.
What is the value of the history that is written by a doctor? That kind of a judgment we can get.
You can give us 2 copies.
Not 2 pieces, of course, 2 copies. Part 2 also, no? Oh.
Really? We don't have any hearing. Nothing. Oh, we have fixed 2, no? No, but we have to ask, I'll talk to Baisha also whether I can, we can hear the.
আমার মনোপত্রটা কি মোবাইলত নোখোলা আছে পাসওয়ার্ড চেঞ্জ
Where
কৰিছে
is that? That-
Two কালিয়ে change করতে।
No.
এনেও নোখোলা কিবা এটা নতুনকৈ গ'ল
ঠিক আছে, okay.
অবলা
Okay. Yes, madam?
no we have no objection
No objection.
No.
Okay, just you take down this last order, para 1. You are Miss L. Sharma
L Sharma
for United India.
yes madam
Mr. SP Sharma is not here.
not here my lord
Okay, you just say. And, item 2, you just, para 2, you say, Miss L. Sharma appearing for the United Insurance Company Limited submits that the compensation amount has been deposited in the registry of this court along with the interest. So para 2 is the same, except that and Mr. PP Sharma appearing for National Insurance Company Limited, this is not there. That's all. Only she is there, okay? The applicant. Who is the applicant?
Marina Khanum. Mother of the deceased.
Oh, no. Who has filed this application?
We have filed, my lord,
Huh?
United India Insurance, my
No,
lord.
Oh, no,
We are
for
appellant.
Marina Khanum.
Marina Khanum. Who is
Marina
Marina Khanum?
Yes, I told you.
Mother of the deceased.
The applicant is present in person along with MD Hamidur Rahman, bracket respondent number 2, and Habibur Rahman, respondent number 3. Huh? Right. I have also seen the voter ID cards issued to the applicant and the respondents number 2 and 3. The numbers of the voter ID card issued in respect of house number 12, Halliday Ganj, Halliday Ganj, Gang, Halliday Ganj, comma, District West Garo Hills, 794104, shows that the electoral voter ID cards of the applicants, respondent number 2 and 3, and respondent number 2 and 3 are KCJ 0667. What is this? 0667. Three zero three. Is this 303? 303. Comma. KCJ 0669-838 and X07, no, XO 70142-463. Huh? XOZ 0142-463 respectively. Huh? The next paragraph, registry is accordingly directed to release the compensation amount deposited by the insurance by the United India Insurance Company Limited and National Insurance Company Limited to the respondent, to the applicant, to the applicant, Marina Khanum. On proper identification.
Yes.
So they are all married. They are married. You are married, no?
Yes.
Married and
Husband, wife.
son. No problem. No family problem. The IA is accordingly disposed of. The voter ID cards of the applicant, comma, the respondent number 2 and 3 are made a part of the record and marked as annexure X, Y, and Z respectively.
मेजर बोलने के लिए मेजर
pertaining to the issue in hand, and as such, it would not be proper for this court to, for this bench to pass an order in this regard. However, as the as the prayer of the petitioner is urgent, the registry is directed to list this matter before the appropriate bench, without one of us, bracket, that is Justice Michael Zutambula, on 16. This is the matter of 16.